Swayam Prabha. Digital India. Educated India.
Namaskar, I am Dr. Kalpana Sharma, Assistant Professor, Faculty of Law, Delhi University. Today, we are going to start with the new subject, Legal Research Methods and Methodology. Today is the first lecture on the topic, Legal Research Methods and Methodology, and we are going to start with the introduction of legal research methods and methodology with importance of socio-legal research. So, in this lecture, we are going to cover introduction, what is the meaning of research, research methodology, what is the difference between research methods and research methodology, what is the nature and objectives and scope of legal research, what is the broad nature and approaches of the legal research, why legal research is so important, and with this we will also see what is the scope of socio-legal research. With this, we will also try to understand that why socio-legal research is so relevant, why it is so important, and with this we will discuss the overall conclusion of today's lecture. Let's start. What is research? Etymologically, the term research is derived from the French word recherche, meaning to research. This research is a word which is a combination of two syllables, re plus search. Research means searching again, especially to get knowledge. Here, re means again and search means looking for something. So, research means when a researcher tries to investigate, sometimes he tries to inquire, and sometimes when he is proved to come with some knowledge, with some finding, some conclusion, we call that researcher is trying to research on a particular topic or an area. And that's why we can say that research is a careful and detailed study of a topic to gather more information about it. Now let us understand that what is the meaning of research. Research means to search or to find out and examine again. Now the word research means examine again. Now this is a very essence of the process of acquiring knowledge, that a researcher has to find the solution while he is trying to collect the data, he is trying to review the literature, and for that he has to again and again go to library, collect the data, go through the topics, then collect the information. That's why the research is very important to collect some relevant information about any particular topic. So, it is in common parlance referred to a search of knowledge. In fact, research is a systematic and careful investigation for new facts in any branch of knowledge. What does it mean? It means that research is systematic and careful investigation, meaning that a person cannot do research if he has not framed, if he has not finalized how he will pursue, how she will pursue his research, whether the research is doctrinal or whether it is non-doctrinal, whether he want to be study the statutes, legislation inside the library, or he or she want to go out in the field to collect data, to interact with the people, to get the information, and then want to write down his research work. So, when we see the dictionary meaning of research, it simply says that research means a scientific study of a given phenomena. So, scientific study of a given phenomena means that a researcher has to be plan out his research, and only after that he will try to see in detail the problem, collect the data, and then he can interpret the issue, the problem regarding that particular phenomena. Redman and Mori, they defined research as a systematic effort to gain a new knowledge. So, in these two definitions, the one thing which is common, that dictionary meaning research definition said it is a scientific study. Redmond and Morey, they said that this is a scientific effort. So in toto, we can say to acquire new knowledge, what is important, that research should be done in a systematic manner. It should be in a systematic way to collect the data. So far, Dr. P.V. Young is concerned, he also emphasized on scientific undertaking. He also said that research is a scientific undertaking. It is aiming to discover new facts or to verify old facts, sometimes analyzing the sequence, interrelationship of the facts, and then the causal explanation which is derived within an appropriate theoretical frame of reference, develop new scientific tools, concepts and theories which would facilitate reliable, valid study of human behavior, and it is done by means of logical and systematic technique. So, research is a scientific undertaking. So, the aim of the research is either to discover the new facts or verify the old facts. For example, we have a POXO Act of 2012. Now, we want to see that whether the POXO Act, after its implementation, is actually achieve its objective to protect the child from sexual abuse or not. So, this study need to be do in a scientific way. The researcher has to be planned that how he will approach to the sexually abused child, what kind of a question he or she will ask from the child, whether the child will be comfortable to answering the questions and all that. So, according to Dr. P.V. Young, research is a scientific undertaking. It aims to be discover new facts. Maybe researcher will get some new information while he or she will interact with the children who are sexually abused, or maybe he try to verify the old facts or the objective of the act with which the act was implemented, that whether the sexually abused childrens, they are actually getting benefit of the legislation while the cases come into the knowledge of the court or not. Now, if we see the definition of Crawford, he said that research is simply a systematic and refined technique of thinking, employing specialized tools, instruments and procedures in order to obtain a more adequate solution of the problem that would not be possible under ordinary means. So, according to the definition of Crawford, he said that research is simply a systematic and redefined technique of thinking. So, researcher has to be think again and again that what kind of a special tool he or she has to be used while pursuing such kind of a research. If it is a doctrinal research, what kind of a material or matter the researcher need to be study. If it is a non-doctrinal research, what kind of a tool researcher need to be used to complete the research. So, basically when we try to conclude that what is the meaning of research, we would say that in a research, researcher need to be rational in his thinking process. Researcher need to be expert and exhaustive in treatment of the research. Researcher need to be capable to get solutions of the issue or a problem in hand. Researcher need to become close to the exactness or correctness of the statement which he has made for pursuing this research. Researcher need to be analytical. He need to be analytical and analyze the adequate data. Researcher need to understand the relationship between facts and theory. Researcher need to have a constructive attitude. He must have the critical observation, and he should be very, very careful and very conscious while he is recording the analysis after collecting the data. And with this, the honest and the hard work is a very, very important and essential key for pursuing a research. So, in simple words, research can be defined as any investigation. Now, this investigation is scholarly investigation where the researcher want to search for truth. Researcher want to see the facts and he want to assure certainty about certain things. So, research can be best described that it is a process where the researcher try to self-correcting himself. It is the foundation of a scientific method. It is scientific because it establishes cause and effect relationship between variables and the validity of these variables which is yet to be tested. And therefore, the research play two prominent roles. First, it contribute in enlightenment of knowledge, and secondly, it help to solve many complex problems of the society, and to sort out the complex problems of the society, the socio-legal research is very, very important. So, when we discuss the research, that how research will be pursued by a researcher, we can say that firstly he has to create a process. It is a creative process. This research will create something which is positive, which come with some conclusion, and to come to that, researcher has to do research in a systematic manner. Systematic manner means if this is a non-doctrinal research, if this is a non-doctrinal research, if non-doctrinal, then researcher has to plan what kind of tools he will use, what will be the objective of this study, what are the research questions he want to address, what will be the universe of his study, who will be the stakeholders, and what kind of data he want to collect for the completion of his research. So, systematic means that researcher has to be planned in a very proper way what, how and why he want to collect the data. And with this systematic study, the another important aspect is that this research should be logical. There must be some reason behind pursuing this research. So, logical reasoning or reasonableness is again a very, very important aspect of a research. Now, this systematic and logical perspective further gave a purposeful result for the research. So, when there is an objective or purpose a researcher has to pursue this research, definitely the result will be accurate, or sometime the researcher will almost very close to the findings of the result when he want to pursue research. And then next is we will discuss now what is research method and research methodology. Normally the students, they misunderstand that research method and methodology is a one and same thing, but no, it is not. There is a difference between research method and research methodology. So, let us understand first that what is research method. Research method is a specific procedure for collecting and analyzing data. And when researcher planning research methods, there are two important factors which the researcher will make. So, the first thing the researcher will decide how he or she will collect the data. Now, so far the data collection is concerned, if it is a doctrinal research, then researcher will certainly go to library, he will collect some article, books, statute, legislation, and with the help of the secondary data or maybe with the help of the primary data, he will continue his research. He will collect the information which he want to be used in his research. Second, the researcher has to decide how he or she will analyze the data. So, if the research is doctrinal, then all the material is available in the library. But if the research is non-doctrinal, here on the first point, if the research is non-doctrinal in nature, if it is non-doctrinal, then researcher has to decide that whether he will pursue his research with the questionnaire, or he want to interact with the respondent with the help of interviews, or he want to simply observe the respondents in a specific area or in a specific setting, and with the help of that he want to collect the data. So, how he or she will collect the data, this is very important, key for the research. And secondly, how the data will be analyzed by the researcher is also very, very important for the research. And to decide the research method, these 2 points are very, very important for researcher to understand. So, research method basically consists of all techniques. As I said earlier, that researcher will decide that whether he will pursue doctrinal research, non-doctrinal research, whether he will collect data inside the library while using the primary and secondary sources, or whether researcher will go to the field. When he is pursuing the socio-legal research, he will go to the field, he will collect the data either by questionnaire or by interviews or by the interview schedules or through the observation of the respondent in a particular settings. So, research method basically consists of all techniques, strategies and tools which are employed by a researcher to complete his or her experiment work and find out the solution to the problem. So, we can conclude that research method refers to the techniques or tools. So, if he want to go with interviews, suppose researcher want to conduct an interview with the respondents, or if he simply want to observe, so observation is another tool, or if he want to go simply with the questionnaire. So, all these are the methods, to conduct a research. So, research method refers to the techniques that are used by researcher in conducting his research, and thus research methods are employed by researcher for collecting and processing of data, and therefore, the method is about following a procedure. Now, when he is using questionnaire or while he is using the observation method, maybe interview, he is following a procedure to collect the data from the respondent. And in simple words, we can say this is something, this is the way he tried to complete his work. This is the method he want to do something, he want to collect his data. Now, coming on the research methodology. Research methodology is a systematic and theoretical approach to collect and evaluate the data throughout the research process. So, ultimately, the purpose of a research method is to prove the credibility, validity and reliability of a chosen research method. So, research methodology is a specific procedure or technique which is used to identify or to select or sometime to process and analyze the information about the topic. So, research methodology, it is firstly the researcher here will try to identify the problem. He will try to identify the problem. For example, if the researcher want to see that why the juvenile within the age of 13 to 15 years are indulged in taking drugs. So, he identified that, okay, fine, this is the topic I have to be work on. So, he identified his problem. So, after this, he tried to collect the evidences on that. He collected some evidences on that. He collect the data. How he collect the data? Maybe he collect the data from the health department. Maybe he collect the data from a particular school. Maybe he collect the data from any particular geographical area. And then on the basis of that collection of data, now the researcher try to analyze that data. So, firstly, identify the problem. After identification of the problem, researcher, he tried to collect the evidences for the same. He tried to collect the data for the same. Now, what will be the tool to collect the data? That we have already discussed in research method. That method will tell you the tools or technique to collect the data for further analysis. So, here researcher tried to identify the problem. Then he tried to collect the evidences or data for the same. Now, how the data will be collected? That the research method we have already discussed in research method. Now, after the collection of this evidences or the data, researcher try to analyze this. And after the analysis, now he will come to some findings and then he try to dissemination that. And after the dissemination, that information will be used further, maybe for the policy making, maybe to make some better laws or maybe make some better policies to prevent the small children within the age group of that 13 to 15 to indulge in taking drugs. So, this is a complete process. How the research will take place, we call now this is the research methodology. Methods talk about the techniques or a tool the researcher will use, while the methodology is a complete procedure or a process which will be used by the researcher while doing a research. And that's why we can simply identify that when the techniques and procedure which are used to obtain data, we call this is method. And the theory, how research should be undertaken, how he has to be collect the data, how that data will be analyzed, and what will be the use of that data for better policy making, just to take some steps to avoid, to prevent such children to take drugs or indulge in drugs activity. We call that this is the theory, this is the complete process which the researcher has planned to pursue or continue the research. We call this is research methodology. So there is a difference between methods and methodology. Now see how these method and methodology are different. If you see on your screen, see first the research method, it focuses on techniques and tools used to gather data. So basically methods are talking about the techniques, they are talking about the tools which will be used to gather the data. So far the methodology is concerned, now this is the overall strategy. This is the overall strategy, this is the overall framework of research, that how research will be pursued, how the research will be take place, in which area, what will be the tool, how researcher will collect the information, all the strategy, all the planning, we call this is research methodology. Secondly, if you see the research methods, we can say it involve specific procedure. Specific procedures mean when the researcher identify, okay fine, I have to be observe the behavior of juveniles in a shelter home or in a fosterage home, then he will observe, he will use the technique of observation, because he cannot rely on the information which has been given to him by a child who is between the age of 5 and 10. So that's why he simply want to observe the behavior of the children there. So it involves a specific procedure. So here the researcher identify that I will observe the behavior of these juveniles who are indulged in a very small or petty offences like theft of a very petty things. So he want to observe the behavior of their children, and that's why he has to be specify that which tool he want to use while he want to obtain some information regarding those children. So far the research methodology is concerned, as it is already mentioned, that it deals with the theoretical and philosophical underpinnings. Researcher always try to see that how he has to be step ahead, how he has to be move on to collect the data, and for that he deal with the theoretical aspect of that problem, as well as he will also try to see the philosophical aspect of that problem. Now, if you look back on the side of research methods, you will see that research method determine the type of data to be collected and analyzed. Yes, this is correct, because the research method determine, it decide that what type of data need to be collected and analyzed in what kind of a problem. For example, if researcher want to observe the behavior of the people while they are driving their car or a motor vehicle in a busy roads, or maybe in the area where there are so many red lights, right? Whether they are using the helmet, whether they are crossing the red light or not. So he cannot ask a person that whether you are crossing a red light or not. Obviously, the person will say no. So here the only method that researcher can use is observation method. So he has to be observed that how many people actually follow the traffic rules, and how many people they actually violate the rules, right? So here researcher determine that I have to be collect the data, and for the collection of that data, the tool which I will use is a observation method. Now coming on the side of a research methodology, see, research methodology is a strategy which is guiding the researcher in selecting appropriate research methods. So the research strategy will help researcher to decide that what tool or what technique is helpful for him to collect the data. So the example of a research method are experiments, surveys, interviews, observation, questionnaire, and the methodology is either qualitative research or a quantitative research, and sometimes the mixed methodology or mixed methods is also become a research methodology. Next, now let us discuss that what is the meaning of legal research. So till now we discussed that what is a research, what is a research method, what is a research methodology, how research method is different from research methodology. Let us understand that what is the meaning of legal research. See, legal research means research in that branch of knowledge which deal with the principles of law and legal institutions. So, legal research refers to any systematic study of legal rules, principles, concepts, theories, doctrines, decided cases, legal institutions, legal problems, issues or questions, and sometimes the legal research is a combination of all of them. So, for example, if the researcher want to study the legal institutions, so if researcher want to see that whether the child welfare committees, they are actually helping the children to protect from the sexual abuse, or whether these committees are actually helpful for the protection of the children who are in need of care and protection. So, now in this type of a research, the researcher will definitely try to understand the objective behind the establishment of that institution, why that institution comes into existence, what were the objective behind establishing this institution, and how institution is working. If we take an example of a legal problem, for example, if researcher want to understand that Article 21 of the Constitution, it talk about that no person shall be deprived from his right to life and personal liberty. Now, this is an example. Now, researcher want to see that whether the people who are illegally migrant in India, or the people who are foreigners here, or the people who are otherwise here but they are not the citizen of this country, whether their human rights are protected in this country or not. So, this is the legal problem where so many newspapers they cover the stories that there is a violation of a human rights of the migrants or maybe the persons who has taken asylum in the country. Now, the researcher frame a problem that he want to understand that what are the legal problems here, and he want to address that. So, in legal research, sometimes the legal problems, issues or questions, these are the main concern of the researcher to take into consideration the particular topic and initiate his research. So, we can say that legal research is a systematic finding for what? Or ascertaining a law on a identified topic in the given area, as well as it is an inquiry into the law. And that is why this is a study of a relation between the world of the law and world that purports to govern. Now, moving on, if we have to be discuss the meaning of legal research with the dictionary meaning, see, the Black Laws Dictionary defined legal research, the finding and assembling of authorities that bear on a question of law. So, the finding and assembling of authorities that bear on a question of law means that Black's Law Dictionary defined legal research, that here the researcher, he tried to find out the problems, he tried to assemble the different authorities that actually bear the question of law, mean that address the question of law. So, what does it mean? It means legal research is a process. Researcher used to identify, he tried to find the laws including the statute, regulations, court opinion that apply to the facts. So, in most instances, the purpose of legal research is to find support for a specific legal issue or a decision. So, let us understand that what are the objectives of legal research. Objective of legal research. Legal research may be undertaken for a wide variety of purposes, and its nature may largely depend on what a person intend to achieve by a research activity and motivating factors. Now, let us see in detail that what are the different objectives of a legal research. First, Legal research try to ascertain the nature, purpose and policy of legal rules and the principles that govern the specific situation and determine their current relevance, utility, adequacy or efficiency, etc. Research ascertain the nature and purpose and policy of the legal rules. Whether these legal rules, the policies, they are adequate to protect the rights of the citizens of the country. For example, if there is a policy for the betterment of the women in the rural area of India, then researcher might be take this topic to pursue his research, where he want to see that whether the policies are actually helpful for the better economical and social status of the women in the rural area. So, here the objective of this research will be, researcher want to ascertain the purpose and the policy of the legal rules. He tried to see that whether the rules or the policy is adequate or is it sufficient to address the issue in hand or not. Secondly, the objective of legal research is to examine legal principles and precedents as established by the courts and tribunals or the other authorities. They are having power to decide issues and disputes with the view to determine their scope of application in a given situation. So, sometime researcher in a doctrinal research, he tried to evaluate, he tried to understand the decisions of the courts, the decisions of the tribunals or some other authorities who are having power to decide issues and dispute, that whether the issues and disputes are actually addressed in a proper manner by the courts and tribunal as per the law established by the legislature or not. So, to examine legal principle and precedents, the researchers sometimes continue or adopt to do the research. Now, the another objective of legal research is it examine the concept of law. It tried to examine the ideas, sometimes the notions, theories or the doctrines in a respect of any matter which is related to law or with the view to ascertaining their relevance, correctness, validity, utility and the truth they contain. The next objective of a legal research is to examine the concepts, ideas, notion, theories or doctrines in respect of any matter which is related to law with the view to ascertaining their relevance, their correctness, sometimes to see their utility or the validity or sometimes just to find out the truth they contain, right. So, the next objective of a legal research is to identify the weakness of an existing law, weakness of the existing law or defect in a particular area of law or to highlight issues that are not covered or partially covered and examined by the law. To identify the weakness of an existing law or defects in a particular area of law or highlight issues that are not covered or partially covered and examined. The another objective of a legal research is to examine the nature and composition of a legal institution, the objective behind its establishment. For example, researchers want to understand that in a different state there is a state human rights commission. So, how far the state human rights commissions are successful in protecting the human rights of the people in that particular state. How many complaints the state human rights commissions get against the violation of the human rights of the people. So, researcher might opt a one or two states to understand the working, the functioning, the objectives of the state human rights commissions. So, in that way, researcher try to understand, he try to examine the nature and composition of the state human rights commission, which is a legal institution, and then he also try to see that what is the objective behind its establishment and how far the institution is successful to achieve with the objective with which this institution was established. The another objective is to compare legal provisions, principles or institution existing in a particular legal system. Now, this is the legal research which we can say it is a comparative legal research where the researcher try to do a comparative legal analysis of the laws, maybe a law of India on a particular area and law in other South Asian country on the same particular issue. So, sometime the objective of a legal research is simply to do a comparison between the legal provisions or the principle and sometime also of the institution which are existing. The objective of a legal research is also to identify what are the advantages or disadvantages of a law or a legal institutions. So, sometime researcher try to identify that what are the advantages, or maybe there is some problem, there are some disadvantages, there is some problem on a certain aspects of a law or a legal institution. So, this is also very important objective of a legal research, where the researcher try to understand what are the merits, demerits of a certain aspects of a law or maybe of a certain any legal institutions. Another objective of a legal research is to study the cause that lead to the adoption of a particular law, principles of a legal institution. For example, in India, the criminal law amendment came in 2013. Now, the objective of the researcher is to study what are the causes that led to the adoption of that particular law, why the amendment in a criminal law come in 2013, and what is the principle, and sometime maybe the principles or the legal institutions, how they are working. This can also be the objective of a legal research. Sometime researcher also try to understand the social problems, maybe some issues, maybe some questions, and he tried to examine how the law deal with it. For example, India is the growing economy in the world. We are at the fifth number in the world at the economy. Now, with the changing scenario and with the changing need of the nation, we are totally digitalized. But whether the digital literacy reached in the rural India or not, this might be a question which the researcher want to address. So, when he tried to study some social problem, any issue or any question, and then he tried to see that how the law is dealing with that, how the government is working to make the people digitally literate while they are using their mobile phone for the transaction of money, or while they are using these phone for the other social things. So, when the researcher try to understand some social problem or issue, we can say that this is the another objective of a legal research. And sometime researcher want to ascertain what is the merit and demerits of the old law. What was the relevance of the institution which was earlier there, and then after studying the merit and demerits of the old law or the old institution, researcher come with some new suggestions, with the suggestion of some new law, with the suggestion of the establishment of some new institution to address the problem in hand. Now, let us understand what is the scope of legal research. See, law is made by legislature, it is administered by the state, and it is interpreted by the judiciary. And that is why it is very important for us to understand that what is the scope of a legal research. Legal research encompasses a broad range of the activities which is conducted by a legal professionals to find and understand the law. So, when we discuss the scope of a legal research, it include statutory research, it include case law research. So far the statutory research is concerned, statutory research from its name mention that it involves researching the statutes. It involves the study of the law which is enacted by the legislature. So, legal researcher in the statutory research, he often try to locate the text of the statutes. He tried to determine what is the current status of the statutes. He tried to understand how the statutes have been interpreted by the court, how the court has given the relevance or importance to that particular statutes. Researcher try to understand this. We call this is their the researcher is trying to understand the statutory research and he tried to interpret the relevance of the legislature in this way. The case law research. The case law research involve the court's opinion. The case law research involve the judgment pronounced by the Honorable Supreme Court, the decision which are issued by the judges. Then in case law research, the legal researcher analyze cases to understand the legal principle. The researcher give the interpretation of the law to determine how the law has been applied in a specific situation. And then he tried to find persuasive authority to support their argument. Now, secondary source research. The name secondary source research itself explains what does it mean. It means that researcher is involved in consulting the secondary sources. Now, what are the secondary sources? Secondary sources of legal researchers, encyclopedias, they might be treaties, they might be the law review articles, they might be some statutes, they might be some good journals which deal with the legal issues, which provide the commentary on legal issues, and in this way researcher try to understand the complex legal concept with the help of the legal encyclopedia, the different articles, the newspaper articles and different secondary sources, whatever is available in the library, maybe on the database, maybe on the internet. The another is the legislative history research. Now, this involves researching the history of a statute to determine the intent behind its enactment. So, when for example, when the Criminal Amendment Act 2013, when it was enacted, the objective behind the implementation or enactment of this act was to cure the offences against the women in India. Legal research sometimes may review the legislative document such as committee report. So, on the basis of the Justice Verma committee report, the India come with the Criminal Amendment Act of 2013. Sometimes researcher try to understand the hearings, sometimes he try to understand the debates to understand the legislative intent, that what was the idea behind the enactment of that particular law. Legal ethic research is also very important research, because this research involve the rules of professional conduct that govern lawyers' behavior. So, in legal research, researcher need to determine whether a particular course of action comply with the ethical issues or not, whether the lawyer are behaving properly in the court or not. So, the Indian Advocate Act is a example of the act which come with that how the lawyer has to be behave in the court. Foreign and international law research. The foreign and international law research, it basically involve the research of a law and legal principles from other countries or international organizations. So, again this is a kind of a comparative legal research where researcher try to understand the legal principles on one particular issue within the two countries. Sometimes researcher try to understand that what is the law in India or in some other country. So, this is a kind of the comparative research within the one country with another country. So, legal researcher may need to understand how foreign or international law they are applied to a particular legal issue. For example, how UNO and its organs, their functions and what kind of relations they have with the different states. For example, how India, without being a signatory to the International Convention on the Refugee, is actually giving asylum to the refugees and entertaining them in this country and providing them all the basic human rights and providing them all the facilities here. So, for the functions of the state, constitution is the source, and hence a wide research scope is also there to be to do in depth study. Now let us understand that what are the different nature of legal research. Broadly, the legal research can be of a two kind. So we have two different research methodology. One is quantitative research and another is qualitative research. So almost all of legal research are variation of one or other. It means that legal research either may be quantitative research or a legal research may be qualitative research, right? Now, the time which is needed to accomplish the research, the environment in which research is to be conducted or some other factors, they are very important to decide that what type of research the researcher want to pursue. Let us understand that what is the qualitative research. This research is more exploratory in nature and it can be descriptive in nature because this is qualitative. So, qualitative refer to a social study which is based on the field observation that are analyzed without statics. So, when a researcher is trying to observe that the behavior of the people on the red light, on the red light, that whether they are following the traffic rules or not, we say this is a qualitative research. Field research, participant observation, open-ended interviews, focus group studies, they are the common type of qualitative research. Further, the qualitative research method, it can be used to answer a wide range of legal questions. What kind of questions? Questions like interpreting the meaning of a legal statutes. It is used to understanding the application of the law in a particular case. It is used to identify the underlying principles of a legal doctrine. Sometimes it is also used to exploring the impact of the law on a particular group. Quantitative research is concerned with the measurement of quantity or amount. So, it means that quantitative research is applicable to all such phenomena that can be measured in terms of quantity or a number, where researcher want to collect the data in number. So, quantitative research used as interview, questionnaire or measurement, and then they present the result in the form of statistical table and graph. So, quantitative research is used to testify the hypothesis that a particular law has a particular effect, measuring the impact of a legal change on a particular group of people, determining the relationship between two or more legal variables. Now, this is very important. Quantitative research, it determines that what is the relationship between two or more legal variables. So, we will discuss the variables in the coming lectures, but the quantitative research, it try to determine the relationship between one or two legal variables. Now, see what is the approaches to legal research. So, legal research is often classified into two broad categories. When research is concerned with some legal problem, some issues or questions, we referred it as a doctrinal research. Sometimes we called it a pure research, sometimes we called it a theoretical research. But when legal research involves a study of some aspect of society, or maybe some problems, or maybe some issues, maybe some questions, we call this is a socio-legal research. Now, let us understand that what is the doctrinal research. So, doctrinal research, as I already said, is sometimes called a pure legal, sometimes it called as academic, sometimes we called it a traditional, sometimes we called it a conventional research. It is essentially a library based study, means the researcher not need to be going to field to collect the data. Researcher only sit in the library, he collect the material, whatever is needed for the research, maybe whatever is available in the libraries, maybe in the archives, maybe in the other databases, maybe on the internet. Researcher collect the data and then he start his study. So, the basic aim of such research is to discover, to explain, sometimes to examine, analysis and present a very systematic form of facts, principles, provisions, concept, theories or the working of certain laws. So, doctrinal research, it focuses in answering that what is law, and in which the researcher try to find out definite answer to the legal questions. Definite answer to the legal question. For example, the purpose of this research is to check the validity of the existing law in the light of changing society. Because law always need to be changed with the changing need of the society, and that's why the law is dynamic. So, the purpose of this research is to check the validity of the existing law. in the light of the changing society, whether the law is up to the mark with the changing needs of the society or not. The doctrinal research is mostly a research in law rather than a research about law, because it mostly focus on developing the theories and perspective. So, the law of torts and administrative law, they are the two most significant example of the doctrinal law. Now, let us see what is the socio-legal research. Socio-legal research, it is an interdisciplinary field that combines the study of law with the society, with the social sciences, with the sociology, with the anthropology and the political science. And the basic aim of this research is to understand the relationship of the law and the society, how law and legal systems shape and are reshaped by the socio-economic and culture factor, because law is operative in the society. So, it is important to understand the relationship between the law and the society. So, socio-legal research is also termed non-doctrinal research. It is also said empirical research. It is also called sometimes the field study, and this research refer to study some aspect of the law in operation. We can also say law in action or sometimes law in context, which means that a study of how law operate in social context or how law deal with the social problem is the basic area where the researcher want to do his research. Basic feature of the socio-legal research is that socio-legal research is a systematic study into social or political or other fact condition. It tries to discover unknown or partly known factors. Sometimes the socio-legal research try to ascertain why and how human beings behave in a certain way in a certain factual situation. For example, the researcher try to find out that why drug abuse is more common in a certain particular group of a people who are living in a certain geographical area than in another. So, for this, the researcher has to be go to the field, he has to be collect the data from there. So, here the research is connect with the society and he try to understand that what kind of a law is needed to prevent such kind of incident in the society. And then this socio-legal research is also important to identify the cause and effect of a certain problem. Why prison in certain geographical areas are more overcrowded, or to find out why there is a rise in a certain type of offences, and then what is the effect on public attitude and the social life, or why there is a huge backlog of cases in the court, etc. So, basic features of socio-legal research also include a field study where a hypothesis is usually framed and then sought to be tested or verified, or a question is raised and which sought to be answered by the research. So, in addition, socio-legal research can also have practical application. It can inform policy decision, it help to shape legal reforms, and sometimes it also provide a basis for the advocacy and the social change. So, in conclusion, we can say that a socio-legal research is a important aspect of a legal education. Why? Because it helps the students to broaden the understanding of a legal system. It helps the students to understand what is the impact of a law in society. It helps the students to understand that what is the relationship of a law with society. And in the words of Professor Upendra Bakshi, he says that lawyer must know much of the sociology as the sociologist must know much of the law. And according to Professor Bakshi, socio-legal research is very important in mapping of an Indian legal system, in mapping of a formal and informal legal system. He also suggests the socio-legal research for beneficiary and for the victims of administration of justice. He suggests that socio-legal research should also be conducted to understand the relation between law and poverty, compensatory discrimination of a section of people such as scheduled caste and tribes, etc. So, area of socio-legal research, it expand with the development in the law and technology, and hence a dynamic or a developing society, a legal researcher must adopt a multi disciplinary approach, as the legal problem in the society will be largely connected with the socio-economic, political and the psychological issue. So in today's lecture, we discuss about the meaning of research methodology. We understand that what are the research methods and what is the research methodology, how research methods they are different from research methodology. With this, we also discuss about the legal research, what is the meaning of legal research, what are the objective, what is the scope, what is the nature of legal research, what are the different approaches of legal research. And with this, the very important thing which we discussed today was the socio-legal research, the meaning of a socio-legal research, the features, the importance of a socio-legal research, which is very, very important for understand the law and the impact of a law on the different aspects of the society. Thank you.
Hello everybody. Now the discussion which I would try to talk to you is about the excitement which I always feel, and I am sure you will also reciprocate as I proceed and when you do the course, is in the area of multivariate statistical problems and multivariate statistical analysis. So, what we mean by multivariate? So, we know that statistics is a subject where you have a lot of data, you try to analyze that using different type of techniques like estimation problem, MCMC techniques, then forecasting and the area of time series analysis, and then try to basically find out the best forecasting tool which you have, such that you are able to gain the maximum amount of information from a set of data. Now, in the recent past, as we see that multivariate statistics has really increased in a very exciting manner, and if I trace back to history, it has been going on slowly for the last about 70-80 years, but now the time has come where it is being used in a very big way, and the techniques which we all know, but which are being utilized with new vigor are in the area of, say for example, canonical correlation technique, in the area of factor analysis, in the area of conjoint analysis, in the area of clustering analysis, in the area of multi-dimensional scaling techniques, structural equation modeling, be it in the area of finance, be it in the area of engineering, be it in the area of social sciences, be it in the area of economics, such that you are able to gather the information from the data in such a way that it really gives you some useful set of information. Now, in the recent past, there has been also an explosion of large and complex data sets, but added to that there has also been a commensurate increase in the computing and the statistical techniques. So, obviously, the question comes that if the statistical techniques are there for so called small data, not the big data, not the data which is of terabytes and so on and so forth, where you use different type of computers to store the data, the question obviously comes that are those statistical techniques really relevant when we use them in the big data sense? The question is, they are not always relevant, they may not give you the best results. So, what we are seeing in years to come, and I feel very excited about that, is that how the new tools which we have already learned in statistics, in multivariate statistical analysis, are being redrawn, are being, say for example, remodeled in such a way that they can be utilized along with the techniques of computing in a very nice manner, that we are able to garner the information from big data very successfully and very nicely in such a way that they are able to portray a sense of information which we all long to have from big data, be it in, say for example, medical sciences, be in the area of finance, be it in weather forecasting, be it in transportation, so on and so forth. So, obviously it means that students, participants who are in a position with some brief mathematical background to take multivariate statistics and statistical tools as a subject in this program are assured of a very exciting future, where they can use these tools to both gain the knowledge as well utilize them in a very best practical sense, such that they are able to do some justice to the information which is given to them and get the best information from the data sets. I wish all the participants in this course the best of luck, and I am sure they will also reciprocate the excitement which I have for this type of courses. Thank you.